There's a specific kind of knock, not the knock from a neighbor borrowing something, not the delivery person, not anyone you're expecting. There's a knock that's different, heavier somehow, more deliberate. And before you've even gotten up from the couch, something in you already knows this isn't ordinary. You look through the peephole, uniform, badge, maybe two of them. And in the next 30 seconds, you're going to make a series of decisions that most people make on pure instinct, without any awareness that they're making decisions at all. Whether to open the door, how far, what to say, whether to step aside, whether to answer what you're being asked. And the reason those decisions matter, the reason I want you to understand them before you ever need to, is that your home is not the street. The rules at your front door are genuinely different from the rules during a traffic stop or on a sidewalk or in a parking lot. Your home carries the strongest legal protections of any space in constitutional law. The Fourth Amendment's protection of your house is not incidental, it was foundational. The framers of the Constitution were specifically, historically, deeply familiar with what it meant to have authority knock on your door and demand entry. And yet most people, when that knock comes, swing the door open wide without thinking. Step back, invite the situation in. Not because they're uninformed about constitutional rights in the abstract, but because nobody ever explained what those rights look like at 11 o'clock on a Tuesday when there are two uniforms at your door. Before we go any further, the framing that matters. This is not anti-police content. Officers knock on doors for all kinds of legitimate reasons. Welfare checks, follow up on a report, looking for information about something in the area. Most of those interactions are completely routine. Most officers doing this work are doing it properly. This video is about equipping you with accurate information for a situation where what you do in the first 30 seconds can have genuinely significant consequences. Consequences that flow from understanding, or not understanding, what you're actually required to do at your front door. That's not adversarial. That's practical. Let's establish the legal foundation, because everything else flows from this. The Fourth Amendment explicitly protects houses from unreasonable searches and seizures. The Supreme Court has described the home as the place where Fourth Amendment protection is most stringent, stronger than a car, stronger than a bag, stronger than a public space. What this means in practice: without a warrant or a recognized legal exception, police generally do not have the right to enter your home. Not a right to peek inside. Not a right to stand in the doorway. Not a right to enter. They can knock. That's allowed. Any member of the public can knock on your door. Officers can stand on your porch and speak with you. They can ask questions. What they cannot do, in most circumstances, absent a warrant or an exception, is cross the threshold. Now, the ID question at the door specifically. The stop and identify laws that require people to provide their name and identification in certain states, those laws generally apply to people who are lawfully detained in public. They apply to investigatory stops on streets and sidewalks when an officer has reasonable articulable suspicion of criminal activity. They generally do not apply to someone standing inside their own home, answering a knock at the door. You are typically not required to provide identification to an officer who has knocked on your front door in the absence of a warrant, an arrest, or specific circumstances that create a different legal situation. I want to be careful here because this is an area where the specifics of your jurisdiction matter. State laws vary. The circumstances of the specific contact matter, but the general principle that the ID demand at your door carries different legal weight than an ID demand during a lawful public detention is real and important. The exceptions, because they're real and you need to know them. A warrant. If officers have a valid search or arrest warrant, the analysis changes significantly. They are required to present it if asked. If there's a warrant for your arrest, officers can lawfully enter to execute it. If there's a search warrant, they can enter and conduct the search it authorizes. Your rights don't disappear with a warrant, but what you can lawfully do in response changes. Exigent circumstances. Courts have recognized that genuine emergencies can justify warrantless entry. Officers in hot pursuit of a fleeing suspect. A genuine, immediate threat to life. Evidence being actively destroyed. These exceptions are real. They're also narrow. They're not, we thought something might be happening. They require actual exigency. Welfare checks. This one is worth its own moment. When an officer is at your door because someone reported a concern about your well-being, the dynamic is different from a standard investigative visit. Courts have addressed welfare checks in various ways, and what's legally permitted can depend significantly on the specific circumstances. I'll come back to this in the scenario section. Consent. And this is the one that catches the most people. If you open your door wide and step aside, physically, courts have recognized that this behavior can constitute implied consent to entry. You didn't say come in, but your actions communicated it. That's the one most people don't know, and it's the one that changes the situation faster than anything else. Let's talk about the door itself, because the physical geometry of this matters. You do not have to open your door to speak with an officer. You can speak through the door entirely. Your voice carries through a closed door. You can open it a few inches, speak through the gap, pass documents through if needed. You can open it partially while keeping your body in the doorway without stepping aside. What many people do instead is swing the door open completely, step back out of the natural physical response to someone at the door, and find themselves in a situation where the threshold has been crossed before they made any conscious decision to allow it. The door position is a decision. Make it like a decision. The phrases that work. Said calmly, said clearly, said without hostility. When officers knock and you don't know why they're there. Through the door or a small opening. Can you tell me what this is about? When asked to open the door further or asked to come inside. I'm comfortable speaking from here. When asked for identification, can I ask what this is regarding? I prefer to understand the situation before responding. If they claim to have a warrant, can I see the warrant, please? Examine it through the gap if possible. Read what it authorizes. A warrant for one thing doesn't authorize everything. If they don't have a warrant and you want to end the conversation, I appreciate you coming by. If I need to follow up on this, I'd prefer to do so through my attorney. If they indicate they're going to enter regardless, I want to be clear that I'm not consenting to entry. Do not physically block the door. State your position verbally, clearly, and let the legal process address what happens next. One thing that generates a lot of confusion, the difference between speaking with officers at your door voluntarily and being required to do so. Officers can knock. You can choose to answer. You can also choose not to. Not answering your door is not obstruction. Not answering your door is not suspicious behavior in a legal sense. It is choosing not to participate in a voluntary encounter, which is your right. If you don't answer, officers who lack a warrant and don't have exigent circumstances generally cannot enter. They may leave a card, they may return. The situation continues through proper legal channels. If you do answer, the conversation that follows is generally voluntary. You're participating by choice, which means what you say, what you reveal, what you invite are all choices you're making. Neither answering nor not answering is objectively the right move in every situation. Knowing that both are available to you is what lets you make an actual choice rather than a default. Scenarios. Because the general principle hits differently when you're in a specific version of it. What if they say it's a welfare check? This is the version most people find hardest. The framing is concern for you. Refusing to engage feels alarming from the officer's perspective and can escalate the situation in ways that a standard investigative knock might not. A welfare check doesn't automatically override your privacy rights, but it does create a different kind of pressure, and courts have addressed this in various ways depending on the specific circumstances. Practical approach. Engage through the door. Demonstrate that you're okay and coherent. I appreciate the concern. I'm fine. Is there something specific that prompted this? Being demonstrably responsive tends to resolve welfare checks without the situation escalating. The goal of a welfare check is confirmation that you're okay. Providing that confirmation through the door accomplishes the goal. What if it's late at night? The time of the knock doesn't change the legal framework, but it changes the emotional calculus significantly. The disorientation of being woken up, the alarm of lights and voices, the reduced cognitive function at 2 a.m, all of this creates pressure toward automatic compliance. You can take a moment. You don't have to respond in the first 5 seconds. Take a breath, get oriented, engage through the door rather than opening it reflexively. What if it's about a neighbor or something in the area? They say they're just looking for information. This is a common framing for door contacts that aren't specifically about you. Officers in the area investigating something, looking for witnesses, trying to piece together a timeline. You can be helpful without opening your door wide and inviting in a full conversation. You can answer through the door. You can say you don't have relevant information. You can decline to participate at all. Being a good neighbor and being legally prudent aren't mutually exclusive. They just require a little more thought than swinging the door open by reflex. What if they say they just want to ask you a couple of questions? The same analysis as any voluntary encounter. You don't have to participate. If you choose to, you're participating voluntarily. What is this about? Is a reasonable first response that gives you information before you've committed to answering anything. What if they have a warrant and you're not sure if it's valid? You can ask to see it. You can read it. You can note what it does and doesn't authorize. You should not physically resist or obstruct execution of what appears to be a valid warrant. And immediately, the moment the situation allows, contact an attorney. Even if the warrant is valid, an attorney can examine whether it was properly obtained, whether it authorized what was done, and what your rights are in the aftermath. What if there's more than one officer and the situation feels like it's escalating? Stay calm. Keep your voice even. I want to cooperate, and I'd like to speak with an attorney before going further. That phrase slows things down and reorients the conversation toward a process that protects everyone. Don't match the energy of an escalating situation. Your calmness is not submission. It's the most effective tool you have. Here's what I want you to actually remember from all of this. Your home is not the same as the street. The rules are different. The protections are genuinely stronger. And the mistakes people make at their front doors aren't made because they're uninformed about constitutional rights in the abstract. They're made because nobody explained what those rights look like in the specific, real, slightly alarming moment when there's an unexpected knock. You don't have to open your door wide. You don't have to step aside. You don't have to show ID in most circumstances, absent a warrant or a lawful public detention. You don't have to invite a conversation you're not prepared for. You can speak through a closed door. You can ask what this is about before responding to anything. You can say you'd like to speak with an attorney before responding further. You can be completely polite, completely calm, and completely clear about what you are and aren't going to do. That combination, polite, calm, clear, is more protective than any specific legal knowledge because it creates a documented record of someone behaving reasonably while exercising their rights. That record matters. But here's something I want you to think about between this and the next video. We've talked about the knock on the door, the officer standing at your threshold, the decisions you make in those first 30 seconds. What about what happens when they don't knock? When the interaction isn't at your door but is instead a letter, a summons, a request that arrives in writing and asks you to come somewhere, to provide something, to respond to something, without any officer standing in front of you creating immediate social pressure. Most people handle those moments even less carefully than they handle the knock, because the pressure isn't immediate, because it feels like there's time, because the document looks official and compliance feels mandatory. It often isn't. And knowing what those documents mean and don't mean is the next thing worth understanding.